Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act, where we interpret and understand the Patent Act in simple manner for us to find solutions with regards to situation that we may encounter for an idea, an invention, or patent in general. So far in our journey, we were able to identify a person, the true and first inventor, who is authorized to file an application at an appropriate office. The true and first inventor, his assignees, or the legal representative who are authorized to file an application at the appropriate office. Next up, we need to help these folks with the forms and the documents along with the timelines that are required for initiating such filings. Moving on, Section 7 and 8 of the Patent Act helps us with the format and the timelines which are required to initiate the filing. First thing first, an application for a patent can only be directed towards one invention. If there are multiple inventions in an application, the patent office will raise objections to it. Now, what kind of objections and how to overcome those objections we will discuss during the later part of other episodes. For the timing, we need to understand that an application for a patent can only be directed towards one invention. Now, Form 1 is required to file for an application for a grant of a patent. Now, it's not uncommon for inventors to assign their applications, assign their rights, assign their inventions to other person interested or the company that they work for or to a business partner. To understand the further requirements, we need to understand who is the applicant. Now, as we know, true and first inventor could be the applicant, an assignee could be the applicant, or the legal representative of the true and first inventor could be the applicant. Now, in case of assignee or the legal representative, there is a requirement for these folks to provide a document that can establish their right to apply. This could be a deed of assignment or another assignment document which clearly indicates that the inventor has assigned the right in the invention to these applicants. Or the inventors can sign the Form 1 stating that the invention has been assigned to the applicant, or applicant has the proof of right to apply based on the assignments that they have done. Proof of right to apply, the deed of assignment or assignment deed, or the signed Form 1 needs to be filed within 6 months from the filing date. It can be filed during the filing also, but it can be filed within 6 months from the filing date. Moving on, in case the inventors are not the applicant needs to file a declaration confirming or declaring that as per his knowledge, these are the true and first inventors using Form 5. Now, Form 1 is signed by the inventors, assigning the rights to the applicant. Form 5 is signed by the applicant, declaring that the persons are indeed true and first inventor. This has to be filed with the application, or it can be filed within 1 month from the filing date. Moving on, as we are filing an application for a patent for an invention, we need to describe the invention in detail for the patent office to know more about it, for the public at large to know about your invention. That is done using Form 2. Now, you can file a provisional specification or complete specification at the time of filing. Now, why to file provisional application, when to file a provisional application, we will go over such discussions in later episodes. For the timing, at the time of filing, you can file a provisional specification or complete specification. A fun fact here, if the application is a convention application or a PCT national phase application, you cannot file provisional application. A provisional application cannot be filed for a PCT application or a convention application. Remember this. Talking of convention application and PCT application, it's not uncommon for applicants to file in multiple countries as the patent rights are territorial in nature. You need to file in all the countries where you seek the protection. Related to this, there is a requirement from the patent office that you need to provide all such details, the details with respect to all your foreign filings to the patent office using Form 3. you need to provide a statement which provides details pertaining to all the foreign filings that you have done. Details such as application number, application date, country, and the status of the application. Along with that, you also need to sign an undertaking stating that you will keep updating the patent office with regards to any development that happens with these applications or any other application that you may file from time to time. Now, these proactive requirements need to be met within 6 months. So 6 months from the filing of the application, you need to file the Form 3 stating out details, and any development that happen for all these applications outside India, you need to update the Form 3 and file it again within 6 months from such updates that happen. So this is the proactive requirement that has been put on the applicant by the controller or the patent office. However, controller also, out of the turn, can request the applicant to provide details with regards to these applications. He can demand documents also. What kind of details in documents? For instance, any office action that has been issued by other patent offices, objections raised by them for the patentability or novelty of the invention. As such, there is no binding on the patent offices to accept each other's results. Every patent office take their own decisions considering their own laws that are there. However, it's always good to have how other patent offices actually treated a similar invention. You need to provide these details in 6 months from the time the controller actually asked you for the details. Considering the documents that are required, the timelines that need to be followed, and other procedure requirement that needs to be managed, usually applicants assign or employ patent agents to act on their behalf. In case a patent agent has been employed, he needs to be authorized. He or she needs to be authorized. You use Form 26 to authorize a patent agent to act on your behalf. From there on, all the communication that happen from the controllers or from the patent office side with regards to this application happen between the controller and the patent agent. And patent agent, of course, in turn will update the applicants all the time. With this, now we know that Form 1, Form 2, Form 3, Form 5 are the basic forms which are required to initiate a filing. In case a patent agent is also employed, Form 26 is required for the person to act on your behalf. Here is the summary. So important sections to remember here are 7.1, which states one invention per application. You cannot file multiple inventions in an application. In case inventors have assigned their right, then proof of right to apply for the applicants should be filed as per 7.2. It could be filed using Form 1 or deed of assignment. Then requirements with regards to foreign filing needs to be filed using Form 3 as per Section 8.1 and Rule 12. This is important. 8.1, Rule 12. Then Form 5, where applicants are declaring that these are the true and first inventor. This is 7.3. So with this, we now know that who is the person authorized to file an application, what is the appropriate office to file an application, and what documents and what timelines to follow while initiating a patent application. In the next episode, we will discuss in detail the requirements of Form 2 for drafting the provisional or complete specification. What kind of details, what kind of sections need to be there for the patent office to accept your filing. Till then, take care, goodbye, and read well.